The concept of shared parental responsibility provides a framework for effective co-parenting. Florida law, Florida Statute 61.046(17), defines shared parental responsibility as a court-ordered relationship in which both parents retain full parental rights and responsibilities with respect to their child, and in which both parents confer with each other, so that major decisions affecting the welfare of the child will be determined jointly. The parent, in whose care the child is, shall have the responsibility of making day-to-day decisions regarding the child's care, maintenance, and welfare. The parties shall consult with one another on questions of religious upbringing, discipline, financial, moral, social, recreational, and legal matters, school and educational programs, changes in social environment, and non-emergency health care, both medical and dental. Each party shall have an active role in providing a sound moral, social, economic, and educational environment for the child. The parties shall attempt to work cooperatively in making future plans consistent with the best interest of the child and in amicably resolving any disputes that arise. The parties shall at all times conduct themselves and their activities in a proper manner which will promote the welfare and the interests of the child. Each party shall promptly notify the other of any serious illness or accident affecting the child. Each party shall have access to records and information pertaining to the minor child, including, but not limited to medical, dental, and school records. Each party shall attempt to ensure that the child maintains unhampered and free access with both parties. Each shall encourage a feeling of affection between the child and both parties. Neither party shall do anything to hamper the natural development of the child's love and respect for the other party. While the minor child is residing with one parent, that parent shall make all reasonable efforts to facilitate communication between the other parent and the child, both by telephone and through the mail. However, in every event such telephone communications shall be reasonable in nature. Neither party shall do anything that would estrange the child from the other party. Sole parental responsibility means that responsibility for a minor child is given to one parent by the court, with or without rights of visitation for the other parent. A court may award sole parental responsibility for a minor child only if it finds that shared parental responsibility would be detrimental to the child. The court must consider evidence of spousal abuse as evidence of detrimental effect on the child. If the court determines that shared responsibility would be detrimental to the child, and it finds that such abuse has occurred, it may award sole parental responsibility to the abused spouse and make such arrangements for visitation as will best protect the child and the abused spouse from further harm. In the state of Florida, the breaking of the marriage contract in the courts is referred to as a dissolution of the marriage. The division of property, child support, and the primary residence of the child are usually settled outside of court. Lawyers competent in family law will be helpful in this process. Family mediation. The court's family mediation program was developed to provide people with a choice, leaving the responsibility for making decisions where it belongs, with the family. While every family may not resolve all of the disputes regarding the future care of the children, most have found mediation useful in reaching acceptable agreements, defining their ongoing relationships and responsibilities to each other as well as to the children. Mediation is a way of settling your disagreements about the care of your children during or following separation and divorce without a courtroom battle. The process directly involves both parents in searching for a resolution of the problems which families normally experience during separation and divorce. Through mediation, the rights and responsibilities of each parent are identified. The goal is to reorganize the family, not to award custody to one parent and make a visitor of the other. The mediator, who is trained and certified to address family issues, acts as a third-party neutral and not as a judge or counselor. The mediator's role is to assist the parents in arriving at a voluntary, mutually acceptable agreement. If an agreement is reached at mediation, it is signed by both parties, the mediator and the attorneys, if any. When the agreement is approved by the court, it is binding upon the parties. If the parties do not reach an agreement, the mediator simply reports that outcome to the court. The parties then resume their lawsuit before the court. You must have a court order to participate in the court's family mediation program. Asterisk, either party can request that such an order be entered. Once the court order has been issued, the parties are required to attend and participate in the mediation conference before they can go back to court. Mediation conferences are confidential and no information from the sessions will be revealed by the mediators to any other person, including the judge. Asterisk, there are family mediators in the private sector who can mediate family issues, but participation in these sessions is voluntary and requires both parties' consents.